Welcome to Landlord Self-Help Center's module about Landlord Tenant Board orders. The information offered in this presentation is intended as general information. It is not legal advice. If you need more information, please contact a legal service provider. In Ontario, the Residential Tenancies Act is the provincial law that governs most residential rental agreements. It defines the rights and responsibilities of both landlords and tenants and outlines appropriate reasons for giving a notice of termination. It also establishes rules and frameworks for adjudicators and the Landlord and Tenant Board procedures. Orders can be issued by the Landlord and Tenant Board in multiple formats, such as an interim order, ex parte order, hearing orders, and consent orders. For more information about the different types of orders, visit the Landlord and Tenant Board website. In some cases, the Landlord and Tenant Board order can be voided. The most common case involves arrears of rent. If the arrears are paid in full to the landlord by a specified date in the order, the tenant has voided the order and cannot be evicted. If the tenant does not void the Landlord and Tenant Board order or moves out of the rental unit by the specified date, the next step is to file for an eviction with the Court Enforcement Office, also known as the Sheriff's Office. A request to amend an order can be filed with the Landlord and Tenant Board to correct clerical mistakes, such as a calculation error made by the adjudicator, while a request for review can be filed with the Landlord and Tenant Board if a serious error of law or fact had occurred on the final order. Both of these requests must be filed no later than 30 days after the date of the original order. Refer to the interpretation guidelines on the Landlord and Tenant Board website for more information. Appeals of the Landlord and Tenant Board orders are made in Divisional Court, a branch of the Superior Court of Justice. For more information, please visit the Attorney General's website. Please note that the Landlord Self-Help Center does not provide legal advice on appeals. A request to reopen an application can be filed if the application was resolved by a consent order under Section 206 of the Residential Tenancies Act, or a Landlord-Tenant Board mediated agreement. A request to reopen an application can be filed if a party did not meet the terms of the Landlord and Tenant Board mediated agreement, or if one of the parties was misled. Thank you for watching this module about the Landlord and Tenant Board orders. The information offered in this presentation is intended as general information. It is not legal advice. If you have a specific issue or situation, please contact a legal service provider.